Hey everyone, it is Kara Williams back with another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, I like to dive right on in. And yes, I'm going to talk about mostly H-1B cap season. So, first thing I want to talk to you about regarding H-1B cap season is the cap season timeline. We are in the throes of H-1B cap season. So last Wednesday, February 28th, USCIS finally turned on, launched, opened, whatever word you want to use, the new organizational accounts. So if you are an employer and you are looking to enter someone into the H-1B lottery, you must create a My USCIS account. If this is your first time entering someone in the lottery, you'll only know the new organizational accounts. If you entered someone in the lottery in the previous fiscal years, then you will notice some difference in your My USCIS account. If you already have a My USCIS account from previous years, from entering someone in the H-1B lottery, you don't need to do anything to get the new organizational account features. They will automatically be turned on when you log in. So that's not something that you need to worry about. But those enhanced features were available for the first time last Wednesday for new My USCIS account holders, and they were turned on last Wednesday for prior My USCIS account holders. Okay, so we know that you must have a My USCIS account if you are an employer and you are looking to enter someone into the H-1B lottery. When do we start entering people into the lottery? When does that system open? So once you create your My USCIS account, then there is a little bit of a waiting time. And so we wait until the system opens up and allows us to start entering their registrations. That system is open from noon Eastern Standard Time, so 12 noon Eastern Standard Time on March 6th, which is this Wednesday, and runs through, again, noon Eastern Standard Time on March 22nd. So we've got a solid 2 weeks, maybe a little bit more than 2 weeks, to get your folks entered into the lottery. So let me say this about USCIS, the My USCIS accounts, the enhanced accounts. Technology, we love it. We also sometimes don't so much love it. I would not recommend waiting until March 22nd at 10 o'clock in the morning to get your folks registered into the lottery. This is just how I do it. I tend to wait a couple of days after it opens. It's technology. They've got these new enhanced accounts. There are going to be some glitches. So we're all going to have to roll with those punches. So I tend to wait a couple of days. So my colleagues that are first in there and don't mind being first and don't mind working through those hardcore glitches at the beginning, that's cool. I love them for that. I like to take a little bit more of a conservative approach. So I wait a couple of days and then I get all my folks entered into the lottery. But the lottery is open again, noon Eastern Standard Time, starting March 6th, and it closes noon Eastern Standard Time on March 22nd. So no matter what your strategy is, whether you are first out of the gate on March 6th, or you are, last on March 22nd, just make sure that you are between noon on March 6th and noon on March 22nd. And again, that is Eastern Standard Time. So once the registration closes, again, noon March 22nd, USCIS will then run the lottery. They are running the lottery slightly differently this year. They are making it what they're calling a beneficiary-centric lottery. So if an individual has multiple employers that have entered them into the lottery, that is fine. The USCIS this year is pulling based on the individuals. So they will take the individual's passport number. That is what they will use when they are drawing the lottery. So it is possible and most likely will happen that when one individual is selected in the lottery, they may have been entered into the lottery by more than one employer. That individual then can go to the various employers, and say, hey, I want to work with you. I don't want to work with you. It gives them a little bit more leverage, a little bit more bargaining power when they are finalizing their offers. So the lottery now is much more beneficiary centric. In terms of the numbers in the lottery, those are still the same. There will be 65,000 that will be allocated towards individuals that have a minimum of a bachelor's degree. There will be a separate carve out for an additional 20,000 lottery slots for individuals that have received a master's degree from a U.S. Institution. So 85,000 total, 20,000 set aside for those who have received a master's degree from a U.S. institution, and then that remaining 65,000 are for everybody else. So that system remains the same. The numbers remain the same. It's just how the Immigration Service this year is trying to prevent against fraudulent entries with having a more beneficiary-centric system. Two things that you should know in addition to when we can file. So we can file starting on April 1. You want your applications to get there no earlier than April 1. So they will run the lottery somewhere between March 22nd and probably a couple days before April 1st. And then they will notify us again through the My USCIS account. But two things that you should know. The premium processing fees have already gone up. Those went up towards the end of last month. So if you want to file your H-1B cap case using premium processing, just make sure that you are using that new premium processing fee, and it will be $2,805. The other thing you should know about filing premium processing is it will no longer be for 15 calendar days, it will be 15 business days. The new fee rule impacted premium processing by saying that all premium processing cases now were business days instead of calendar days when you are counting those days. The second thing is, while they are working through what will be glitches, but we are going to roll with those punches, what will be glitches with the new organizational account, if you opt to file using paper, the I-129 and the associated premium processing form, the 907, if you file them using paper, the Immigration Service is not even going to try to link them to your My USCIS account this year. They are just going to work through what glitches we know will happen for the organizational accounts. They're not also going to try to link those H-1B filings that were filed on paper with the with the online account. If you file online, however, you will have the benefit of having filed it online. You will be able to see everything online. So completely up to you. I will leave that in your capable hands, making that decision. Second thing I want to talk about today, still H-1B, but it's H-1B fees specifically. So we know that when we were filing the H-1B, it was on Form I-129. It is still on Form I-129. The Form I-129 is still used for more than the H-1B application. There are multiple applications that use that Form I-129. So that's all fine, well, and good. What used to be, what is still the case, what will no longer be the case as of April 1, is that all of those application types had the same filing fee of $460, that base filing fee. That is no longer going to be the case. So for employers that have 25 or fewer full-time employees and nonprofits, the filing fee will remain $460. The base filing fee will go up to $780 if the company has 26 or more full-time employees. So that is something that we all need to keep in mind when we are filing these cap subject H-1B applications. A new fee altogether, completely new, never had it before, is being added to H-1B applications. That is what I'm affectionately calling it's an asylum fee. It is a fee that is helping the service run, and will put that money towards the asylum side of the house, and helping them gain income from the filing fees, because it is a fee-based agency to run the asylum program. But again, they have, when they decided on this final rule, when they decided on the final numbers, they also looked at the size of the company. So that extra fee will be $300 for smaller employers, those employers that have 25 full-time employees or less. And that fee will be $600 for employers that have 26 or more full-time employees. So the base fee is different depending on how many employees you have. And the Immigration Service has added a completely new fee to help them run the asylum side of the house. And that is also based on the number of full-time employees that we have in the business. Okay, the next thing we're going to talk about, April 1, April Fool's Day. Hello, we have new fees that will be active on that day. So April 1, we know that the fees go up. I have talked about this. Premium process, as part of that fee rule, the premium processing timing changes from calendar days. It will now be business days. So keep that in mind when you are counting out and you are doing your strategy. Premium processing, as a result of the fee increase rule, is now being counted for business days and not calendar days. There was a separate rule that increased the premium processing fees, that those fees were not upgraded and raised based on this general fee rule. So totally separate rule. Those new fees are totally in, we are off to the races and running with those new fees. I will talk about those in a minute. If as of April 1, if you choose to file online, the Immigration Service is pushing us to file online. There is what they are calling a 50% discount for some filings that are done online versus paper. So if you're filing online, it will be $50 less than if you were filing some of these applications using the standard old, whatever word you want to use, paper method. Big change, which really goes back to like a very old school way of doing things. I've been practicing for over 20 years. This is how we were doing it when I first started practicing. And that is your EADs and your advanced paroles in connection with adjustment of status applications. The current way that we are doing things, current, I mean, today up until the last day of this month, March, we are filing the EAD and the EAD and the advanced parole. There is no separate filing fee for those two applications when they are filed with an adjustment of status. There is currently no fee to renew those applications when you are filing with, when they have been filed based upon an adjustment of status. The Immigration Service is ending that and essentially going back to how it was when I first started practicing. Those are now no longer going to be fee exempt. They now will have their own separate filing fees. So as of April 1, the EAD and the advanced parole will have separate filing fees, even when you are filing them with an adjustment of status. When you then go to renew your EAD and advanced parole after April 1, they will also have filing fees associated with them. However, if you file the adjustment with the EAD and or the advanced parole prior to April 1, you will be grandfathered in to have to be fee exempt for the extensions. That was clarified on the USCIS Ombudsman's call last week, which I sat in on. Because those calls generally have a lot of very good information that I like to pass off to y'all. That was one of the golden nuggets from that call. So if you are in a position where you are getting ready to file your adjustment of status, your advanced parole and your EAD, if you can, you want to get it filed before April 1, because that will then grandfather you in, not to have to pay for the extensions of the EAD and the advanced parole as long as your adjustment of status is pending. If, however, you cannot do that, if that is not available to you, and you are filing that after April 1, just understand that you will have to pay separately for the adjustment of status application, the EAD application, and the advanced parole application. There is, and I already talked about it, there is a new fee that is associated with non-immigrant employment-based applications to help the asylum program based on the size of the businesses. So we went over those when I talked about those fees for the H-1Bs. And again, just because several forms are filed on using the form I-129, they now, as of April 1, with the start of the new fee rule, will have different filing fees. It's no longer going to be the same plain Jane $460 for H-1Bs, Ls, Os, TNs, and E2s, to name a few. They will all have separate filing fees based on the application type. So we want to make sure that we go into USCIS and take a look at that. USCIS has told us that the online fee calculator will be updated as of April 1. So if these fees kind of have your head spinning, there is an online tool that we can use that is, being updated as of April 1 by USCIS. Okay, premium processing, more fees. They went up, but they went up under a separate rule. They went up and they were effective as of February 26th. So I think last week, maybe a week before last, but the end of February nonetheless. So if you were paying $1,500 for your premium processing fee, it is now $1,685. A lot of my clients were paying $2,500. Their premium processing fees will now go up to $2,805. That's right, $2,805. I don't know where they got the 5 from, y'all, but it's $2,805. If your premium processing fee previously was $1,750, it now goes up to $1,965. So again, lots of information on H-1B cap cases, lots of information on the lottery, lots of information on the increased fees. So this was interesting timing on the part of the Immigration Service to have this all come to fruition at one time. So the last thing I want to talk about is national interest waiver. Y'all know I give you a tip on that every Monday as well. So national interest waiver is a second preference category green card application. To meet the requirements, you must have a master's degree or higher. If you don't, you need to show that you have exceptional ability in your field. You also need to show that the proposed endeavor that you want to work in has both substantial merit and national importance to the United States. Second, you need to show that you as the individual, the beneficiary, are well positioned to advance your proposed endeavor, meaning you're well positioned once you get your green card to continue working in your proposed endeavor, whatever that may be. And third, on balance, that it is beneficial to the United States to waive the usual EB-2 second preference requirements of having a job offer, thus having an employer sponsor you, and going through the labor certification process, whereby you advertise the position to make sure that there are no US citizens that are available for that position. So I get this question fairly regularly, and it goes a little something like this. So I'm self-petitioning, which means I want to apply for my national interest waiver without an employer sponsoring me. How can I show USCIS that I'm super serious about this amazing business idea that I have? Now, there are certainly more than one way to do that. One of the things I love about the national interest waiver category is that you can be creative in the documentation that you provide to the Immigration Service. But you still need to provide them documentation, right? You can be creative, but it still has to, you still have to give them documentation that makes sense to them, that you've given them a great explanation. But you can show them a couple of the things that you can provide to the Immigration Service to show them that you are really serious about your business, that you have put, that you have put a lot of thought into this, that you are, ready to rock and roll, is that you have startup capital, right? So show the Immigration Service that we've got some startup capital. And show them that we have letters of intent from, prospective clients, that sort of thing, as well as if you are past sort of the letter of intent phase, if you have proof of actual contracts, if this business is actually in the stage where that you have signed, sealed, and delivered contracts, and folks on the other end of those contracts are waiting on deliverables. Those are three really good ways to show the Immigration Service that you are serious about your business, and that you are ready to move forward. Now, those are not the only things that we can show to the Immigration Service. Again, one of the reasons I love the National Interest Waiver is because you can be creative in the documentation that you provide. But those are just an example of three. And if you don't have any of these three, it does not mean that your application is not going to get approved. It's just, I wanted to provide you all with an example of documentation that you could provide to the Immigration Service. So that is all I have for you this beautiful Monday morning. I am Carol Williams with Williams Immigration, a boutique immigration law firm helping businesses and families navigate our extremely complex and backlogged immigration system. If you have any questions about your immigration case, if you are looking to hire someone that is not a U.S. citizen, feel free to give my office a call. We are happy to have a consultation with you. Have a wonderful Monday and a great rest of your week, and I will see you all next Monday.